And counsel for Carlos Baruf.
So that'd be Mr. Herron as counsel for Mr. Baruf from staff attorney with the Florida Commission on Ethics.
Mr. Herron.
Good morning, Your Honor. May I proceed?
Are you? Oh, there you are. You weren't. Your picture wasn't coming up. It could before you begin. Would you like to reserve any time for your rebuttal?
Yes, Your Honor. I would like to reserve 5 minutes.
Go ahead, sir.
May it please the court. My name is Mark Herron. I am counsel for appellant Carlos Baruf. And as I just indicated, I would like to reserve 5 minutes of time. From Mr. Baruf's point of view, the prime issue in this case is whether this Commission on Ethics can mandate that a street address be used when reporting real property on a Form 1. Form 1 is a rule. Because it's a rule, it's Mr. Baruf's position that the requirement that a street address be used amounts to an invalid exercise of delegated legislative authority.
Mr. Herron, if we were to find that the rule, the form, there's a rule mandated the use of the street address as opposed to, if we were to interpret should as a mandate, mandated the use of the street address when one is available. And if we found that such a mandate constitutes an invalid exercise of delegated legislative authority, but we also conclude that the initial filing did not include a description or location sufficient under the statute itself. In other words, if we do we need to reach the rule challenge? If we excise, for the sake of our analysis, what you consider to be a mandate, and we still find that the filer did not include what we deem the statute to mean by the words description or location, would we need to, or should we reach the rule challenge?
I would concede to the court that if in fact you found that the statute, the requirement of location or description precluded the use of the locations and descriptions that Mr. Baruf used in his Form 1 filings, you would not need to reach the rule challenge. It's Mr. Baruf's position, however, that the descriptions of the properties are consistent with the requirements of the statute. And that, again, is the crux of his issue with respect to that finding. It's Mr. Baruf's position that mandating the use of a street address enlarges, modifies, or contravenes the specific provisions of the law implemented. As we've cited in our brief, Section 112.3145 does not require that real property use a street address. The statute requires, as Judge Atkinson just noted, that the location or description of the property be disclosed.
I have another question about this argument. Presuming again that if, for the sake of discussion, that we find that a mandate of a street address would be an invalid exercise of legislative authority, a mandate of a street address if one is available even. Is there something in the recommended order of the ALJ or the final order of the commission that actually relies on that reading of the statute? I'm reading paragraph 29 of the recommended order. So the respondent did not provide a street addresses, parcel numbers, longitude and latitude, or any other meaningful identification. So even if the ALJ found that a mandate, and I'm just presuming for the sake of discussion that he found a mandate and found that that was not an invalid exercise of delegated authority, where in the recommended order does it indicate that that was the reading of the rule that the ALJ relied on to find a violation?
Well, again, in paragraph 29 that you just cited, he did say, or she did say, that it was not the ALJ said that it was not, the street address was not used, and cited additional, I guess, markers that one would be used to identify the property. The entire prosecution was based on the failure to include street addresses. The commission in its, or even the recommended order in the commission in its brief cites the fact that Mr. Baruf filed Form 1Xs to correct the deficiencies. And they use that as hoisting him on his own petard because, again, he corrected what was the perceived error based on the form. Again, it's Mr. Baruf's position that the descriptions and the locations were adequate to comply with the statute and with the rule. Again, we're going to have to get to this issue of whether the language mandates the street address because of the word should. But I hope I've answered your question, Your Honor.
Yes, thank you.
The law, as we see it, basically says the commission cannot adopt a rule that contradicts the express language of a statute it purports to interpret. And again, that law is cited in the brief, Save the Manatee Club, Southern Baptist Hospital, and Kessler versus Department of Management Services. By requiring that a street address be used, the commission has rewritten the law to include a requirement not in the statute. The commission—
Again, I just want to go back to, sorry, you did answer my question, but you just mentioned, you said by requiring a street address.
Right.
Now, I do agree that portion of the ALJ's final order can be deemed to have dispatched the rule challenge by making a finding that such a mandate, you could read it to mean that the ALJ found that such a mandate would not be an invalid exercise of legislative authority. But you just said by finding, by finding that a street address was required. And I'm having trouble finding where that reading was applied. Again, just focusing on this one paragraph in front of me, the ALJ's finding seems to be more broad. It says did not provide a street address, parcel numbers, longitude or latitude, or any other meaningful identification. I can't read from that the ALJ found that Mr. Baruf had to provide a street address, and because he did not, ipso facto, it was a violation. It sounds to me more like the ALJ was saying that if not a street address, it must be, quote unquote, any other meaningful identification.
Well, and that's one of the issues in this case, Your Honor, as to whether the descriptions of the property were meaningful identification. And again, the commission ties its argument to the fact that the rule also says, and it's cited in the brief, that one must be able to look at the description and from the description be able to identify the property. Okay. Mr. Baruf believes that his descriptions are consistent with, I guess, the language of the recommended order that talks about other meaningful descriptions to identify the property. It's curious that in this case, that one of the issues that there was a finding of no probable cause by the commission was an alleged voting conflict. And the alleged voting conflict involved a property described in the complaint as multiple lots at the inlets. For whatever reason, the commission was able to discern from that description that this is the vote that was alleged to be a voting conflict. And so that description was meaningful, and the commission was able to identify those properties from that. So based on that, we believe that Mr. Baruf believes that the requirement, again, from what the language says, a street address should be used if available or something like that at the end of that sentence, is an implicit statement that there is a mandate that you use a street address. Now, latitude, let me just finish with thought, Your Honor. Latitude and longitude is not going to be meaningful either, notwithstanding the ALJ's thought in her recommended order that latitude and longitude is going to be meaningful. You're going to have to take that information and translate it to something on a map. Same thing with these properties that are identified in Mr. Baruf's financial disclosure.
Now, let me, I always want that raises an issue that I wanted to ask you about. So I understand your argument against what could be inferred to have been asserted by the ALJ and the commission. I mean, presuming for the sake of discussion that they're asserting that that this description, even if it leaving aside the street address mandate, must allow a reader to ascertain the property's identification merely from the form itself. So let's say that we would agree with you that we reject that is a requirement. Isn't there something else more fundamental that something that identifies property by description or location? Wouldn't it be a sine qua non for a location or description of a property in which a filer has a financial interest to have the explanation identify it to the exclusion of all others? In other words, if a filer were to say, units in this subdivision, units in subdivision X, does that actually allow the reader, even upon further investigation, if they went to the plat book or whatever, to differentiate which units were or were not units in which the filer had a financial interest to the exclusion of all of the other units?
I would concede that the person who was looking at the form would have to go someplace else to perhaps identify those specific properties.
And I'm saying something more. I'm saying that isn't it perhaps the case that in some of the descriptions it would be impossible? In other words, if one were to say, I'm conceding your argument. If you gave a something that gave a block and lot number, you can go to the plat, right? You could, there it is. Or if you give longitude and latitude, and one were to go to Google Earth, you could say there it is. But if one were to say 200 acres along Rye Road, for instance, I'm not quoting, but does that identify which 200 acres to the exclusion of all the other acres along Rye Road? Wouldn't it be impossible to perform the function of determining for the reader, even upon further investigation, which 200 acres are the 200 acres this filer has an interest in, to the exclusion of all the other acres abutting Rye Road?
It does not. It does not.
Okay.
It does not.
Mr. Heron, let me expand upon some of Judge Atkinson's questions, because the question I have, and you brought up the voting conflict of interest, and you brought that up. But is there also some concern with someone trying to locate the parcels as to the actual magnitude of the ownership? So when the initial disclosures showed multiple lots, for example, they didn't identify the actual lots, but what is multiple? Is multiple 2 or is multiple like 100? So when at some point of the disclosure to determine what is the magnitude of that financial interest in not the actual monetary, but the actual number of interest in that area, versus just one small interest, because I only own one lot, versus 100.
Judge Smith, I think the answer in the voting conflict context would be there are additional factors in the statute that identify the size of the class that's being affected by the vote. Okay, and so to answer your question is yes, but again, that's not the end all by saying he owns one. It still could be, if he owned one, he could still have a voting conflict. If he owned 100, he could still have a voting conflict. It depends on the size of the class, as well as, again, whether there's any benefit, financial benefit, that accrues to a member of a governing board or a body from that vote. And so there's additional factors that need to be considered other than just the size of the class or one thing or not.
Okay, I guess the concern here is, I understand you're saying it's your position that they mandated a street address. And what if a street address isn't available because some of these are undeveloped properties? But certainly there would be at the very least a tax parcel ID number. Correct?
I agree. And again, if you look at the 1X filings that are in the record, Mr. Baroof, at my urging at that time, said, let's put the street addresses if we can find it, and let's put the property parcel numbers as well to specifically lock it down. But again, the commission uses that subsequent filing to hoist Mr. Baroof on that advice, which again, we think is fundamentally unfair and leads to another issue that I would like to address in my argument at some point in time.
And before you do, let me just ask you one last question. Is there any statutory or rule that addresses the ability of a filer to amend their filings? And if so, is there any sort of time period in which they must do that?
There is a statute that allows a filer to amend. There is really no time period on that. And again, the facts and circumstances from Mr. Baroof's point of view is that he had been filing these forms for a number of years. No one had ever raised a question as to whether they were inadequate. The commission's position, it's not their job to do so, not the job of the SOE to do so. But again, you can amend the forms. And again, when this complaint came in, Mr. Baroof asked me to review them and advise him as to how to file the forms as I would do so.
You are slightly into your rebuttal. Would you like to proceed further into your rebuttal or reserve?
I will save any points I have in my rebuttal. Thank you, Your Honor.
Mr. Burns?
Thank you, Judge. May it please the court. My name is Joe Burns, and I'm a staff attorney for the Florida Commission on Ethics. We're here today because appellant was required by law to file financial disclosure that in relevant part required him to disclose any properties that he owns or any properties that are owned by a company that he owns on the CE Form 1. Now,
Are you contending that should means shall, or are you that a street address is required if one exists? I mean, it says a street address should be used if one exists. Doesn't in this context it mean shall?
No, Judge, it doesn't. It's a suggestion. It's the most expedient and easiest way to comply with the disclosure requirement.
Well, if I were a regulated individual, you know, in any context, and I'm looking at, the giant swath of, of rules we have in the Florida Administrative Code, and it said something like, for this liquor license, you need to do X, Y, and Z, and you need to list the location of the business, and a street address should be used if one exists. You think I would read that as precatory? I say, well, instead I have a street address, but I'd rather just use my PO box.
Well, the PO box. That's
so it's a hypothetical. What I'm saying is, doesn't this mandate a street address if it's available?
No, it's not. It's not a strict mandate. It is a suggestion for the best way to, in order to comply with the disclosure requirement. We do use the word should in another context in the same instructions, where it's simply a suggestion for the best practice, and that is where we suggest that a filer should redact their social security number or any other sensitive information from any attachments that they may file.
Is there a qualifier on that? Or I guess there's the qualifier would be if you are. I guess that applies to everyone because that's exempt from Chapter 119.
It applies to everybody, yes, sir. So now at the DOA hearing, the appellant reviewed his own Form 1 filings, and when reviewing his own disclosures, he couldn't identify what properties he was referring to on his own forms.
Can I go backward? Did the appellant cite cases in which should does in certain contexts create a mandate?
I don't believe so. No.
Do you know if there could be contexts in which should could be construed to be a mandate?
No, sir, I don't believe so. So as as Mr. Herron conceded, the appellant hired, and he stated this at the hearing at DOA, the appellant was subject to a complaint, and then he hired Mr. Herron. And after that, Mr. Herron advised him that his filings were deficient and he should file amendments. So this prosecution was not based on his amendments. It was based on the insufficiency of his original filings that the complainant identified. The commission agreed that they were deficient, and Mr. Herron agreed that they were deficient. That was the basis for the charges, not his amendments. The amendments were, of course, untimely. They were filed years after his original filings were due. It's far beyond any statutory allowance for an amendment.
There's a time limit for an amendment?
Yes, sir. They're
Where is
due
the
by,
statute?
I don't have it in front of me, but it is 30 days after your original filing. It's 30 days after your original filing is due, sir.
You
And you're
can't
saying
amend your
that's
filing?
statutory, that's a statutory time limit?
Yes, ma'am.
So
So-
a 1X can never be filed after 30 days?
So it can be, it's just untimely. It's not that we don't accept it. It's, of course we accept it as a filing. It's not that we reject it and tell the appellant that we won't take it. It's just untimely. His complaint, I believe, was filed in 2017. These forms were from 2013, 14, and 15. And he only filed them after a complaint was filed.
Let me ask this, what if we were to find that this violation that is the subject of this appeal meets the criteria for a de minimis violation, why shouldn't we reverse for the commission to reconsider whether to reconsider its final agency action?
Are you referring to just the property disclosures or all of the violations that he had on?
Well, I'm assuming that's going to be your response. I said this violation.
Understood. So even if you reversed and found the property disclosures to be de minimis violations, you could still affirm based on his other violations, which were for all three forms in question.
We could on the Tipsy Coachman, but what if we don't? What if we think it's a close enough question? In Chapter 120, our authority on appeal is a little bit different than a typical appeal, is it not? For remand instructions, what we can remand for, if we find it de minimis, if we were to find that argument was preserved, I'll get to that. Why couldn't or shouldn't, or what would prevent us, or what should dissuade us from remanding for reconsideration by the agency about whether this was de minimis and should somehow affect the fine imposed or the sanction imposed?
Well, I'd have to concede that if you found every single one of his violations de minimis, you would need to reverse.
What if we didn't? What if we just found the one that was raised on appeal to be de minimis?
I'm sorry, could you repeat?
What if we didn't? What if, address my question? What if you're saying only that would be the only scenario in which we could or should reverse under Chapter 120?
Yes, sir.
Why is that?
Well, as you said, you've got the Tipsy Coachman doctrine. He's had plenty of violations that support his penalty. His penalty was only $500 per inaccurate form, which is very, very
That
light.
goes to the merits. What about our review? But the fact that it was only $500 maybe goes to the merits of whether it was de minimis, and because it was de minimis, maybe there should be a lower fine. But what about our review, the scope of our review, and what we can remand for if we were, for the sake of discussion, to find it that it was de minimis?
I think I'm not understanding the question.
Okay, you said you were making the argument that because the fine itself was itself essentially, to put words in your mouth, de minimis, that it was correlates with the de minimis violation. But my point was about our scope of review under Chapter 120. What prevents us, or should prevent us, or should dissuade us, or do we even have the authority, if we were to find that this violation is de minimis, to send it back to the commission to recalculate the fine or reassess what the sanction is under Chapter 120? What is our scope of review? Standard review, I'd be interested to hear your opinion on as well.
I believe you've got the the authority to do that, to just remand it entirely for a reconsideration of the penalty, or just reverse entirely for no penalty at all if you thought that every single violation was de minimis.
So your position is that we have that our scope of review would allow us to do that if we found that every violation found by the ALJ and the commission was de minimis.
Yes, sir.
And then what is the standard of review for whether a violation is de minimis? What is our standard of review of a commission's finding or an ALJ's finding?
You review for competent substantial evidence for ALJ findings regarding that.
Because, and that goes to the preservation issue. I mean, the ALJ addressed the de minimis argument, but nonetheless, you argue on appeal that it wasn't preserved, even though it was squarely. It seemed to me from the order that it was addressed.
I believe that appellant did not preserve it for review. All he did in his proposed recommended order was quote a statute. That's a conclusory argument. And the standard for preserving an issue on review is that you need to lay out the specific legal argument. The proposed recommended order didn't even go so far as to include a simple statement that his violations were de minimis. It's just a quote of the statute with no reference at all to appellant's violations, no explanation as to why any of the violations were de minimis. There was no explanation or statement that the public wasn't harmed by his violations. There's nothing like that anywhere in the record. So it's our position that it's not preserved for review. But if that answers your question, I'd like to give you some examples of the property disclosures on his original filings that prompted the complaint, and really what brings us here. He entered interest in I-75 office park vacant land with no indication of anywhere along I-75 this land might be located. He wrote lot on University Parkway, Sarasota. Again, no indication of where along University Parkway that land may be or how large. 533 acres on State Road 64, Myakka. And again, State Road 64 is over 77 miles long, and there's no indication where on what side of the road this land is located. Now, these are serious failures because they deprive the public of information which it's entitled to, which is the clarity and transparency regarding a public official's financial holdings. Now, there was some discussion of a voting conflict and how we were able to verify that there wasn't one. However, that's not the standard for satisfying the disclosure requirement. The standard is ensuring that the public has an opportunity to verify that there are no conflicts. And with all of these very, very vague descriptions, there's no way that people could know whether the appellant was voting on anything regarding his own land, because no one could really tell where it was by looking at his forms. So as I stated, there were other violations as well as his property disclosures for all 3 years in question. He failed to accurately state his sources of income. He failed to fill in the dates of disclosure on one form, and on 2 of the forms, he failed to indicate his method of calculating his interests. Now, to touch on our rulemaking authority, I think it's best summarized by section 120.52 subsection 16, which is the statutory definition of a rule. And that definition specifically includes the words, quote, any form which imposes any requirement or solicits any information not specifically required by the statute. In this entire appeal, appellant is arguing that the commission has exceeded its authority because we asked for information on our form that is not mentioned in the statute, but that's right there in the definition of a rule. Rules are allowed to do that. Not to mention, if a rule was only allowed to be as specific as the statute is, there'd be no point in having a rule. There's no purpose for them, but
So, but
Just
that
redundant.
still leaves open the question about whether, the agency's properly interpreting the language of the statute. So, you know, a location could be an address, and I understand your point to be that it doesn't mandate an address. But leaving that aside, but why aren't these descriptions? I mean, would you concede that they're general descriptions? And if they are, why don't they meet why does requiring more than what was given? And what does the form require? How does it describe it? And in a sense that it requires more than what was given. And is that consonant with the original meaning of the word description in the statute?
well, the appellant's filings are not consistent with the definition, with what's required by the statute or the form, the rule. And it's because the filings need to identify the individual property. It's not a description of what he owns. It's a description of any number of properties. You could go find vacant land along I-75 or lots on University Parkway, and they could belong to anybody. Again, some of these filings, he didn't indicate how large the land was or what type of land it was, what was on the lot. There's no telling if they're his or someone else's. So the answer is no. His descriptions do not come anywhere near satisfying the requirements of the statute or the rule.
So you're saying that the word description, there is a limit to how vague it can be,
Absolutely.
and why?
It would defeat the purpose of financial disclosure if you could be that vague. You'd be reading the statute to be meaningless if you read it so broadly that you could file something, you could report and disclose something like that and have that satisfy the meaning of the statute. It doesn't tell us anything. Those descriptions, as I said, you could look at what appellant wrote on his forms and you could end up on someone else's land and not the appellant's. The purpose of the statute is to promote our faith in government and to be transparent. The filer needs to be transparent about what he owns, what he or she owns, and there's no transparency with what he filed. I did want to refer to some specific findings by the ALJ in her recommended order. Specifically, she did find that we had the authority, we were within our rulemaking authority as provided for by section 112.3145 and 112.3229B. She also did make a specific finding that we do accept alternative property descriptions, not just addresses, such as tract numbers, legal descriptions, and by book and page. She found that the language of an adopted rule, as I said, need not and should not be identical to the law implemented. And actually, to backtrack just a bit on the rulemaking authority that we had discussed, these forms were promulgated through the standard rulemaking process, and they went through a review by the Administrative Procedures Committee. They had the option to file an objection if they found the rule improper, but they didn't. So that was the first look that these form instructions had. And then, of course, the second look was by the ALJ herself. And as I was just reading, she found that we were not outside of our rulemaking authority. Our interpretation was reasonable. And so now appellant is asking for a third look by this panel to say that we were beyond our rulemaking authority. She also made some findings regarding his initial filings. Each year of the three forms in question, he only listed about 35 lines of disclosable properties. And on his amended forms, in 2013, he listed 740 properties. In 2014 and 15 each, he listed 640 properties. So his initial filings could not have possibly disclosed or described all of that information which he had in his possession. And he did say at the hearing that he had all of these records in his possession, that he could have identified all of those properties on his initial filings. He just didn't take the time to do it. I think at this time that concludes my presentation, and I'm available for any questions, and I ask this court to affirm.
Thank you.
Thank you.
Mr. Herron?
Thank you, Your Honor. A couple of things in rebuttal. With respect to this 30-day assertion that a person has only 30 days to file an amended complaint, I would cite the court to section 112-3145-11A, which talks about a 30-day requirement, but the 30-day requirement, if you file it within 30 days after September 1, the commission can't proceed with a complaint against you. If you don't file it within 30 days, the commission can proceed with a complaint against you. So there is no timeline for filing an amended Form 1. With respect to the issue of the last issue that Mr. Burns brought up with respect to the number of properties, there's no competent substantial evidence that those properties were not included within the listing, the general listings that were on the original Form 1 filings.
So that was, I think, the one of the later arguments you made. And so in other words, what I understand that argument to mean is that even if even if we were to find, you're saying that there's no, even if the description was perhaps deficient in some ways, there's no evidence that he failed to disclose a property because all the properties disclosed on the 1X were subsumed within the initial filing. But isn't there also an alternative argument that was a failure to disclose individual properties?
Well, again, if in fact the statute requires the disclosure of individual properties, because again, location or description is our argument. Again, if it's within multiple lots at the inlets, there could be 200 lots there, perhaps. And again, that would be 200 filings.
So going back to that, let's say that we understand your argument that there's no evidence that in the 1X that any of those properties more individually disclosed were not subsumed within the property description, the general property description in the initial filing. Thinking about the ordinary meaning of the word description or location, if the language used by a filer doesn't identify the location, the property to the exclusion of all of the properties, does that conform to even the ordinary meaning of description in everyday life? For instance, if I was invited to a party and I said, oh, can you give me the location, or can you describe where it is in the cow pastures that we're having a bonfire? And if I'm not able to identify that location, that property on which we're having a hayride and a bonfire, to the exclusion of all others, then the person really hasn't described the property at all. I can't make the party. I can't get there because I can't differentiate that from all the other tracts of land out in the country.
Well, Your Honor, to respond to that specific example, you're told to go down the road to the third mailbox and turn left and go into the field till you see the barn. I remember going to a party kind of like that when I was a younger person in the last century.
But is X acres on Rye Road the same as saying, go down Route 6 until you see Mr. Smith's mailbox, take the next right, and it'll be about a mile on your left. Isn't there a distinction between those two descriptions? And isn't one not an effective description at all?
One's a little better than the other from our point of view. Two quick questions or 2 quick points, because I'm running out of time, I know. With respect to the commission's argument that this issue about de minimis was not raised below, I would call your attention to the record on appeal at page 800, or at page 800, I believe it's 800. where we raise that issue in our exceptions to the recommended order. We specifically says the alleged violations were de minimis and that no penalty should be imposed. They are in the exceptions that we raised before the commission. And finally, with respect to, and I think we just kind of dealt with this for a second in your last example, the nature of the conflict that is going to be involved is going to be determined by the nature of the vote. For example, we'll go back to the example of property on University Parkway. If in fact there's a vote that deals with properties on University Parkway, there is a specific issue there perhaps of a voting conflict that the public can identify. I believe I'm out of time and I would ask the court to
Well, you have a few seconds left. What about the de minimis thing under 120.68? I mean, can you please, in your time remaining, respond to the commission regarding the issue of whether, if we find that this was de minimis, and how under 120.68, our scope of review, could we reverse when there were several other violations found that we really aren't even reviewing because they're not at issue in this opinion, and we can't review those.
I appreciate that question, and I do have a response to that. The examples of the other things that were the other violations are failure to check a box, which is a violation, but there was no evidence to show that the failure to check the box impacted any disclosures under that were required. Secondly, the issue of the principal and secondary sources of income, all these corporations, and again, the record reflects this, all these corporations that were secondary or primary sources of income were owned by Mr. Baroof himself. And so there is no issue of potential prejudice to what the public is required to know. Every one of these corporations is owned by Mr. Baroof.
Thank you.
Therefore,
Go ahead.
Therefore, we believe it's unintentional and de minimis in nature. Thank you, Your Honor.
Thank you. This concludes unless my colleagues have any other questions. This concludes the argument for this case. At this point, let me make sure I'm directing the parties properly. Let's see here. I think you exit and most importantly, you should probably proceed as you were instructed by the astute staff of this court, because they're better at directing you than I. But I'm going to exit because I'm not presiding over the.
Thank you, Your Honor. We are leaving.
Thank you, Judge.
Judge Northcutt, we're ready for you.